I think that's why
you misunderstand me.
Sorry.
I have no qualms about setting aside the people's democratic action.
I do.
I do it all the time when the Bill of Rights requires me to do it. That's my oath of office. I only object to setting it aside when there is no sanction in the Constitution adopted by the people to do that. And you pick an instance in which the history is not that clear. There are innumerable instances, especially in the most controversial areas, such as abortion and others, where the history is, and the death penalty, where the history is entirely clear. And if you think that the values approach is always clear, the values that you think are the more important are not necessarily the values that I think are the more important. What you think the ex post facto clause was intended to protect against may not be what I think it was intended to protect against. I might think oh my goodness, it's a terrible retro change to all of a sudden make him guilty when he was free of that crime for 20 years. On the other hand, you may say, oh, the only thing it was really meant to do was to make sure that an act which was lawful at one time is not later made unlawful. Either one of those is entirely reasonable. So don't pretend that the values thing provides an easy answer. It provides an answer that the people ought to decide. The people know values. I haven't been, I'm a good lawyer. I presumably was pointed on the court because I'm a good lawyer, not because I know more about the values of the ex post facto clause or whether there ought to be a death penalty or whether there ought to be a right to abortion. I don't know any more about those things than you do. That's not why I was appointed. But I am a good lawyer, and I can read the text, and I can look back and see what the text meant when it was adopted. In some cases it's vague, but it's the cases in which it is vague in significant areas are going to be much, much fewer than the cases in which the values that you want to pursue are values that different segments of the American people will disagree about considerably.
But see, why I think this is important, what Justice Scalia just said, is he's really identified sources of differences where I think there is no right and wrong. That is, when I think of it in my mind, I think you're a lawyer or a judge or a person reading a document, and there are words in it. And now for a lawyer or a judge, we often come across words in statutes, we come across words in the Constitution that don't define themselves. And there's always two arguments on both sides. We're the Border Patrol. We patrol the borders of the Constitution. And I cannot tell you how often in these cases there are two sides to the argument. There are, if not 6 sides. All right, so how do you decide? Well, I think, to go back to really sort of basics, that a judge, when faced with words that you just don't know in a difficult case, has 6 tools to look at. He reads the words. Do the words matter? Of course. And he reads other nearby words. Second, he looks at the history. Of course you should look at that. It may tell you something interesting. Third, he looks at the traditions. What are the traditions surrounding this word that have grown up? Fourth, read the precedent. Read the precedent. Fifth, look at the purpose. And that's what we're talking about, purpose or value. And finally, look at the consequences of deciding one way or the other, not any old consequence in the world, but consequences that have to do with the purpose. If it's a speech case, it's speech consequences that matter. A privacy case, unreasonable search, it's the privacy, unreasonable search consequences, all right? So, I think those 6 tools, text, history, tradition, precedent, purpose or values, and consequences, are relevant to every judge. And if you were going to say no, I'll find cases where you actually looked at them.
I wasn't going to say no. I was going to say that 4 of those 6 factors came out the other way in the 17-year-old execution case that you voted for. 4 of the 6 came out the other way, but essentially you thought it was a good idea not to execute 17-year-olds.
Now we're at the difference, because I think, in my characterization of the originalist view, a lot of weight is put on those four. That if possible, we'd like them always to predict the answer. And maybe sometimes it isn't, but that would be the ideal. And the closer you can come to that, the better. In my view, those factors don't very often give you the answer. I'm not against using them, but I think they don't really give you the answer all that much. And therefore, I look quite a lot to purposes or values and consequences. And the danger of my approach, which you've just heard iterated, is that I would substitute my view of what's good for what the Constitution is about. So I have to take care not to do that. So I write down my reasons very carefully so others can criticize, and amazingly enough, they do criticize. And the danger the other way is, in my view, we separate the law and the Constitution from life. Too rigid. It's got to be, if it's going to be live for 1,000 years, brought down to the life of people today, which means you have to look how these values are applied to today's circumstances.
If
danger,
if judges are implementers of values, not good lawyers, they ought to be elected. Or at least you should select them, and you're seeing it happen in the confirmation process. I don't know whether you know, they become very controversial because the people are not fools, and they have come to recognize that in the last 20 years or so, things have changed. That in fact we have a Supreme Court that believes mostly in an evolutionary constitution, and they are effectively changing the meaning of it from decade to decade. Well, if that's what they're doing, then it's not so important whether this nominee is in fact a good lawyer, an honest person, has a modicum of judicial temperament. I mean, that's nice, but that's not the most important thing. The most important thing is I want to put somebody on the court who has my values, who wants to allow abortion or prohibit abortion, who wants to allow the execution of 17-year-olds or forbid it. And that's what's happening. We're having a mini constitutional convention every time we nominate and confirm a new justice. That's not the way it was supposed to be. These justices were supposed to be lawyers who like other lawyers interpreting a text of a statute, look at the words and what was it understood to mean by the legislature that adopted it. And once you go beyond that, you convert what was a lawyerly institution into a political institution. And when the people realize that, they are going to treat it accordingly. That's what's happening in the confirmation process. It's very sad, but inevitable, I think.
Now, I will say we should get another question. So I'm going to save my absolutely what I see the other side of that one until we get another question, and then I'll work it in.